Your Honors, good morning. Greg Bennett from the Sevier County Bar. I would ask to reserve 5 minutes of rebuttal.
Are there going to be two arguments on this side?
Your Honor, prior to Ms. Crucial becoming involved in the case, her mom's prior attorney did not request oral argument. And so I am assuming that there will not be oral argument on mom's side.
All right, so how much time do you want?
I'd like to reserve 5 minutes.
That'll be fine.
So. And Your Honor, I'd like to start my argument by just pointing out that back in 1775, 13 fledgling colonies began a small scrimmage against a country due partly in result of injustices they saw in the legal system. Our forefathers thought we could do it better, thought we could do a better job of providing justice for all peoples. 250 years later, I now wonder if the juvenile system hasn't failed in that regard. And what I mean by that is the juvenile system originally was set forth and the laws were set forth to protect, preserve, and replenish families, and now it seems like it's only disrupts and destroys families, especially true in this case. One of those justices that I would like to point out, and it's in all my briefs, but on page 37, starting out in the best interest factor, I always point out, the termination of parental rights has the legal effect of reducing the parent's role to a complete stranger, severing forever all legal rights and obligations of the parent. But likewise, it also severs the child's rights to its parents and family. The United States Supreme Court has noted that few consequences of judicial action are so grave to severe natural family ties. That is what I am putting forth to this panel today, panel of judges today. Father has 2 children in his home, 2 biological children in his home right now, both of which were born after the birth of the child that DCS has refused to return. The 3 grounds that DCS alleged to terminate the father's rights, one of which was failure to provide a suitable home, this abandonment by failure to provide a suitable home. The second was persistence of conditions. And the third was that the father failed to manifest a willingness and ability to care for this child. The concerning facts of this situation are that father and mother separated sometime before the child was born. 9 months into the mother having ownership or having custody of the child, because the father was not sure that the child was his, believed it was not his. 9 months later, child comes into custody based on things that happen in mother's life, not in father's life. DCS represented to the father that if he removed his girlfriend from the home, his girlfriend at the time was Miss Sarsons. She is now Miss Sellers, his husband, or his wife, that DCS would return this child, Edward, into that home. Well, for a month, he moved Miss Sarsons out of the home. DCS did nothing to move the child back into the home and basically blames the fact that the father's home is inappropriate.
And she moved back in the home.
She did move back in the home. And again, the couple, still married, are now raising 2 children that they have together.
Well, but what was the reason DCS had a problem with her?
She had a prior severe abuse finding in Knox County with one of her prior children. So DCS took the position that because she had a prior severe abuse finding, we could never place this child in the home of the father as long as he was with this mother, or as long as he was with this person. Yet at the same time, mother has moved in Knox County to get visitation of her 2 children, and she's been successful as it relates to one. I think she still is under supervised visitation as it is to the other. But I don't know how DCS can legitimately argue you have 2 children living in the home, yet the home is not a safe and appropriate place for a third child to be.
Wasn't Paramount, who is now the wife, did she have children that have been removed from her custody?
She has 2 prior to the couple coming together. She had 2 children removed for drug addiction issues. She testified in this case that she had been clean for 4 years. The DCS worker who investigated the case, and this would be a second DCS worker, said that she had no immediate concerns as to Ms. Saracen. She said that the home was small, but it was very clean. She conceded that the concerns DCS had with Ms. Saracen were not immediate present concerns. That's the exact language of her testimony. One of the cases I cited to in my brief was one called In re Quattavon, and that was a 2016 case. The cites was 445 out of this court. And the reason I cited that case is because one of the issues in that case was that the father had a minor child living in his home. Now, when I went back to read the opinion, I didn't see that the opinion mentioned that. But I know that this court raised that very issue. How can you say the home of the father was unsafe for 2 children if he already had 1 child living in the home? And I think that was very influential to this court at the time. I will point out, as it relates to Ms. Saracen, again, John Hinckley has been released from prison. Leslie Van Houten of the Charles Manson era has been released from prison. 780 inmates who waged war against the United States of America have been released from Guantanamo Bay, Cuba. Is juvenile law the only place we don't grant retrievals or reprieves to people? Is the fact that Ms. Saracen, now Ms. Sellers' prior finding of severe abuse going to forever haunt her as it relates to whether or not she can have children in her home? And how can you legitimately justify denying 1 child when you have no grounds to remove 2 others?
Well, I mean, you're asking us to make an assumption that there are no grounds to remove the other 2. I mean, we can't assume one way or the other that they should be or they shouldn't. Or, I mean, the fact we understand that they're there and they have not been removed.
The answer to that is, and this is on page 12 of my brief, that again, the DCS workers testified that there had been a DCS report made in 2022 while this child, Edward, was in DCS custody. It was closed with no services recommended. Likewise, the father has 2 other children that come into his home every other weekend, that are his children. So there are no less than 4 children living in this home that DCS has examined the home and have not removed. And in fact, Ms. Gardner also conceded that...
Let me focus you, counsel, on are you arguing the grounds, or are you arguing best interest, or both? Right.
Arguing grounds.
Tell us why, specifically as to the grounds that the juvenile court found, why the juvenile court erred in finding those.
Because all of the bases for all 3 grounds were based on the fact that the father still had Ms. Saracen living in his home. That was the basis of all 3 findings. It does, again, DCS said that the only concern that they had with father is he had not yet bound with the child as well as he should have. Yet the only person that actually observed his bonding with the child presented a report that said that they were bonding together. And as a result of that, they had no grounds against the father. The only ground that they had was the fact that that DCS refused to bring a child into his home based on allegations against his now current wife.
One of the grounds were interesting to me, persistent conditions. Was the child actually living in the father's house and removed from the father's house?
No, the child was actually removed from the mother, who was living, my understanding, in the lobby of a hotel. At the time, father and mother were separated at that time. They had not been together for several months. And so the child was not even living with father when the child was removed.
You have your time for rebuttal. Thank you. Hear from the appellee.
May it please the court. Good morning, Your Honors.
Good morning.
The decision of the trial court here that terminated mother's and father's parental rights should be affirmed because, first, the termination grounds were established by clear and convincing evidence, and second, there is clear and convincing evidence that termination was in the child's best interest. I'm going to limit my argument to father's arguments here at this point and rely on my brief for mother's termination. As discussed, there are 3 grounds that were found by the trial court here: failure to manifest, persistent conditions, and abandonment by failing to provide a suitable home. I'm going to start with the failure to manifest ground, as many of the facts that are applicable in that ground also cover the other 2 grounds as well. Father did not appreciate the risk that his former paramour, now wife, presented in the home. Ms. Sarson had a criminal past. She had just in 2018 been arrested for domestic assault against her mother. That was witnessed by a police officer. She also had an extensive DCS history. On 2 separate occasions, she had a distinct severe abuse findings against her. Both of those related to her drug use and environmental neglect in the home. Custody of those 2 children have never been returned to her, and at trial, she still only had supervised visitation with both of those children. One of those children, I believe, was actually removed when mother and Ms. Sarson and father had already begun their relationship together. Father claimed he did not know she was using drugs at the time at trial. At trial, father believed that she was clean, though he did acknowledge that there's always a chance that she could relapse, but he did not think that was likely because she was being drug screened at work. He continued to have her in the home on and off again, despite knowing since day 1 of removal that she was not an appropriate caregiver for Edward. While it's been argued that there was never any effort to reunite Edward with father when Ms. Sarson was out of the home, that is incorrect. There was a home visit conducted by Ms. Vineyard when she learned that Ms. Sarson was no longer in the home. She went out, she confirmed that Ms. Sarson was gone, noted just a few things around the house that needed some work, but ultimately informed father that he still needed to form a bond with Edward. Edward was only 9 months old at the time of removal, and father had seen him 1 time. He never sought custody of Edward. He was never involved with Edward at all until the removal. And even when the removal happened, father refused to participate in any visits with the child until DNA testing confirmed that he was the biological father of Edward.
When you say removal, was that removal from father's home or mother's?
So the physical removal was from mother, but father was the legal father of Edward at that point because father and mother were married at the time. They, I think, got married in 2019 and they got divorced in 2021.
Was the child ever physically in father's custody or in father's home for any period of time?
No, Your Honor, he never saw any physical custody or care of the child prior to removal, and
So he was never, the child was never actually removed from father's home then, is that right?
well, Your Honor, he was removed from father's legal custody, which is part of, I think you're alluding to the persistent conditions and abandonment by suitable home grounds. Those statutes were amended a few years ago to include not just the physical home, but also legal and physical custody as well. So because there was a removal from the legal custody of father, and that is reflected in the dependency and neglect records that are included in the exhibits, that prong of both of those grounds are met here. Father also, well, once father did have DNA testing that confirmed his paternity of Edward, His visitation did begin at that point, but it was very inconsistent. He missed about half of his visits with Edward. He had visits twice a month and was good to show up to one of them. He canceled for various reasons, and the trial court found that those excuses were just lacking here. His inconsistent visitation did affect his bond with Edward. The DCS caseworker did not believe Father had a bond with Edward. Father did think he had a bond, but he acknowledged it was not a strong bond if it existed. There was a period after the inconsistent visits where visitation stopped completely from October 2020 until January 2021. Father was offered both in-person and video visits and did not attend a single one. When he did start visiting again, it was the same story, inconsistent visiting, did not routinely show up, and constantly canceled.
Can you explain how the Morrow reflex relates to Father's visitation?
Sure. I will try my best. So there were concerns during visits and following the child's removal because he started showing some developmental issues. My understanding is that when a child is born, as a child's in utero and then also as a newborn, they have a Morrow reflex, which is the reflex that everyone has when they're born. It's a startle reflex. Very soon after birth, within a few months, it does transition into a Strauss reflex, and that's the reflex that we all have, that when we get startled, if it's not an actual threat, we're able to process that and move forward with our day. And when you're stuck in that Morrow reflex, you just remain in a state of stress and tension because you remain in that startled state. It became clear through different therapies that Edward was having that he had not transitioned to that Strauss reflex and still had that Morrow reflex.
And what did Father do or not do that may have impacted that?
So during visits, there were issues. Father was given instructions, very specific instructions on how to interact with Edward, such as he's not allowed to just grab Edward. He can't just be super kissy and huggy with him. He needed to ask permission and tell Edward what he was doing before he touched him, because otherwise Edward would become startled and would get into like the state of dysregulation. Father would disregard many of these instructions. There were also issues with Edward's, I think even before that became apparent, there were issues with Edward's diet, and he had very specific dietary instructions and needs, and Father was also, and just disregarded those as well. He was often hostile to the caseworkers that tried to inform him. He would use foul language towards DCS caseworkers in front of the child. At one point, the DCS caseworker had to be changed about halfway through the custodial episode, about a year into the case, after Father made a comment that he was fantasizing about choking her against a wall and verbally assaulting her. So the juvenile court actually had to enter a restraining order against Father, and we had to get a new caseworker on the case. And so there were a lot of very concerning behaviors by Father during visits. Ultimately, in about May of 2022, the therapist for Edward recommended that Father's visits be temporarily suspended. The concern was that Edward showed some dysregulation following visits, especially after visits with Father, and she wanted time that was uninterrupted by these visits to really work with Edward to help him move past that Morrow reflex. And so there was a few months that the visits were suspended on that basis. And so visits were reinstated in August 2022, which is 2 years after removal, only 2 months before trial, and only at that point did Father begin to more consistently visit with the child and try to do better with following instructions. But again, that's 2 years later, and the child is not in a vacuum at that point. The child's growing and aging and is no longer a 9-month-old and is now over 2 years old.
Counsel, what do you say to opposing counsel's argument that, look, the father's current wife, they have 2 other children, there are children living there with them, other children are there, visitation, I guess. So this shows that it's okay, or the home's okay.
Well, Your Honor, as this court's aware, there has to be a basis of dependency and neglect before the removal of any child, and that is child-specific. So just because there are other 2 children in the home, it's great that there are no issues of dependency and neglect with those children. That's what we want. However, that does not mean that that Father is an appropriate parent for Edward. So Edward does have very specific needs, like I started discussing a little bit already. He goes through multiple forms of therapy. He goes to appointments every week. And his foster mother, who's been taking care of him since removal, works full-time in the home just caring for him, and there's extensive testimony in the record about the efforts that she has to go through to help Edward do basic functions such as eating a meal and using the restroom. And while it is wonderful that father has 2 other children who appear to be safe in his home, that does not mean that he's capable and willing to do what it takes to care for Edward and his specific needs. And that does lead me to the second prong of the failure to manifest ground, which is that returning Edward to father would present a substantial risk of harm to Edward, because again, Ms. Sarson is still in the home. Father does work a lot of hours, and he testified that Ms. Sarson would be the full caregiver for Edward when he is at work. And father thought that he'd be the one that would take Edward to those appointments that he had. But again, father couldn't make most of the visits, so it's difficult to determine how he'd manage to get this child to all of his appointments that he needs and to give Edward the specific care that he needs in the home as well. Edward was doing very well in the foster home. He was getting all of the services he needed. The foster mother had gone through extensive lengths to work with him, to help him move past his issues early on. And it's a pre-adoptive home. They've already adopted 2 other younger children close to his age, and they would like to adopt Edward as well. And again, it's essentially the only home he's known. He's never lived with father and known father as an actual parent to him. Unless your honors have specific questions about the other grounds, I'm just going to quickly talk about the suitable home issue and then move on to best interest. For the suitable home ground, there's argument made that because there are other 2 children in the home, that the house has to be suitable. But this is not an issue where we're worried about father's physical residence. That's never been the case with this case. Instead, it's the fact that he hasn't consistently visited with Edward. He hasn't shown a commitment to learning what it takes to care for this child. He hasn't made the changes that he needs to make to allow for that safe care of Edward. And that's demonstrated again by his failure to attend visits, his failure to end his relationship with Ms. Sarson in those 2 years when it was on and off again. And he just overall just demonstrated a disregard for the instructions he was given to help Edward thrive. As for best interest, this court's aware there are now 20 factors that apply. 18 of them were applied by the trial court, and I'm going to highlight just a few of them briefly. Factors J, K, L, and M are all related. DCS here did make reasonable efforts to assist with reunification. There were assessments provided, parenting classes offered, supervised visits, and arranged therapeutic visits. There was transportation provided, random drug screens, play therapy, recommendations made. There's no argument here that DCS didn't do what it could to help these parents. However, father did not take full advantage of this. Again, he canceled half of his visitations for the majority of the custodial episode and just didn't attend at all for a few months. He didn't heed the warnings and the advice given to him by the DCS caseworkers and Edward's therapists on how to work with his child and parent him appropriately. And he didn't establish a bond with Edward through his failure to attend those visits. D and E as well are factors that apply for father because, again, his visits were inconsistent if they occurred at all, and there were those issues that arose during the visits with his disregard to the instructions and his hostility towards the caseworkers that were just trying to help him, as well as the threat made to one of the caseworkers. Factor T, the mental and emotional fitness of father remained a concern. There was some evidence in the record about father having a little bit of history of mental illness and having medication for that. He acknowledged that there were times that he didn't consistently take his medication when he failed to get them refilled. And just given his behavior during visits, his hostility, and his threat made to the DCS caseworker, there were still major concerns about his emotional and mental fitness to parent Edward as well. And then finally, factors A, B, H, and I are related, and that termination here would allow Edward to have a stable and permanent home. He's been in this home continuously since he was 9 months old. The foster mother works very hard every day to ensure that Edward's getting the care he needs to to eat and to go to the restroom and go to bed and get a good night's sleep. And it's not been an easy task in this case. You all will see in the record pretty parsed out. He was bonded with his foster parents, and he was also bonded with the 2 foster siblings in the home. And changing his caretaker's environment at this point would negatively affect him. Again, this is a pre-adoptive placement. He has a chance at permanency, and in a home where he's receiving his therapies, he's receiving his services, and the specialized care that he needs, and father was nowhere close to being able to provide those to Edward. So if there are no further questions, we ask that the trial court affirm the termination of father's and mother's parental rights. Thank you.
Hear from the appellant.
Honors, let me first address the issue as to threatening the DCS worker. The evidence is clear on record that the father never threatened a DCS worker. He was asked by a therapist what he thought about the DCS worker, and he said, "I'd like to grab her by the neck and strangle her against the wall." Okay. He didn't fantasize about it. It didn't come up again. The therapist then wrote a letter to the court saying we have a disaster on our hand, and that was the fantasization and threat that was made to the DCS worker. Once that DCS worker was taken off the case, by the way, father's behavior, father's consistency, father's desire to pursue the issues that needed to be pursued got much better. All the issues that the state has argued that would prohibit the father from taking custody of Edward all happened in the early stages. I'd like to address the father's inconsistency of visitation. First of all, the father chose that he was not going to visit the child and disrupt the child's life until he knew the child was his.
And what steps did he take to make that, find out?
The DNA test was done.
No, what steps did your client take to find out whether or not he was the father?
My client did not take other steps than allowed DCS to.
And he dropped his pregnant wife off, literally dropped her off at the hospital?
Yes, sir. She had a boyfriend at the time.
My question to you was, and you answered it, you said yes.
Yes.
So,
yes.
Okay. What do you do with the trial court's findings that your client's lack of understanding of the child's conditions and failure to follow directions as to proper feeding and parental bonding techniques have caused major problems both with the child and his providers? Does the evidence preponderate against that finding?
Absolutely. Again, early on, when he first started visiting with his child, the then DCS worker intervened and said, "You can't feed the child this," and he had an argument about that. Okay, later on, when he realized the child did have special feeding needs, he honored those special feeding needs. You know, as far as the moral reflux, father says, "I've got a child at home that has moral reflux." I understand that. The father said, "I started taking those steps that needed to be taken, that I wouldn't approach Edward unless he approached me first." And then he testified, "But there were times in our visits where we'd be walking the greenway and Edward would want me to carry him across the greenway when he got tired. There were times we were watching movies and Edward would sit in my lap." Father even testified there was a time he called me daddy. Okay, addressing what happened with visitation early on, again, first of all, father wanted to make sure visitation would be appropriate because he was the dad. But equal to that, there was a period of COVID that interfered with that. There's a period of time where father had a significant burn to his hand when he accidentally put his hand in a grease oven, French fry oven, at the place he was working at. That caused him to go off to Vanderbilt several times, caused him several procedures that simply interfered with what would have otherwise been visitation.
Well, the trial court found that father has various excuses for those missed visits, that father has various excuses, but the court believes they are lacking. I mean, that's a credibility determination, isn't it?
I would agree that that's a credibility issue, but again...
And you think there's clear and convincing evidence showing that we ought to find otherwise, that the father was believable on these?
Exhibit 67, Your Honor, I would say would be that clear and convincing evidence that the only person who actually witnessed father's visitation with the child said that it was appropriate, that the father is doing these things well. said that the child and the father were bonding. Father admitted, we're starting to bond. Not where we want to be, but we're starting. Foster mother admitted that the child's hard to get to know anyway. He won't just warm up to anybody. Foster mom also stated that as it relates to the child's issues and treating the child's issues, that anybody can learn the same tasks that she learned. She said there's no special significance about it. And then when the trial court actually suspended the father's visits for 2 months to address the moral reflux issue, the child's therapist testified that we really didn't have time to address those moral reflux issues. We were dealing mostly with calming issues. Those took place outside of the father's visitation. You can't really blame those on the father. She also testified that you can't blame the father for some of those things.
All right. I know your time's up, but I want to ask you about one more finding of the court.
Yes, sir.
It said, while Ms. Sellers says she is now sober, the court believes this situation poses a major risk to the child, and the father does not seem to appreciate this risk. I mean, is it your position the evidence simply preponderates against that?
The 4 years of sobriety preponderates against that. I mean, there's always a chance of relapse for anybody. But yes, 4 years of sobriety preponderates against that.
Okay, thank you.
Thank you.
Court's thanks to counsel for both sides. We appreciate your arguments this morning and your briefs on this.